substantive criminal law. Laws can be declared unconstitutional when they violate the main body of the Constitution, any constitutional amendment, or any provision of a state constitution. There are two ways laws are deemed unconstitutional, either due to their content, which means a violation on its face, or due to the manner in which it was enforced. This is a violation by application or as applied. Laws declared unconstitutional are immediately invalid, and any convictions are overturned. Federal courts decide constitutionality of federal laws and state laws that violate the U.S. Constitution, while state courts decide the constitutionality of state laws and can enforce federal constitutional principles in their own state cases. The Bill of Rights, you may remember from your American history classes, consists of 10 amendments. The first 8 amendments attempt to guarantee individual rights. The Bill of Rights was only applied to the federal government until the 1960s, when due to civil rights laws, the federal laws began to be enforced at the state level. The 14th Amendment and other Supreme Court decisions applied the Bill of Rights to the states, except the 5th Amendment provision requiring indictments for serious crimes and the 8th Amendment provision preventing excessive bail. The 10 amendments of the Bill of Rights are, of course, the freedom of religion, speech, press, assembly, and petition, the right to keep and bear arms, to maintain a well-informed militia, no quartering of soldiers, the freedom from unreasonable search and seizure, the right to due process, freedom from self-incrimination and double jeopardy, the right to a speedy and public trial, the right to trial by jury in civil cases, freedom from excessive bail, cruel and unusual punishments, other rights of the people, and the powers that are reserved to the states. In our first part, we talked about 2 different types of criminal law, substantive and procedural. Procedural criminal law are the mechanisms through which the substantive criminal law is enforced. The sources of procedural criminal law in the United States Constitution are the 4th Amendment, which prohibits unreasonable search and seizure, the 5th Amendment, which provides for due process, freedom against self-incrimination, double jeopardy protection, and requires grand jury indictment in federal cases. The 6th Amendment ensures the right to counsel, trial by an impartial jury, speedy public trials, the ability to confront your witnesses, compel attendance of witnesses to aid in the defense, the right to exclude evidence, and the notice and nature of the accusation against the defendant. And then the final source of procedural criminal law is the 14th Amendment, which provides for due process and equal protection under the law. Due process is the procedures and processes that must be followed before a person can be legally deprived of their life, liberty, and property. Equal protection means that persons should be treated equally under the law. So the law cannot distinguish between 2 classes of people. For example, based upon their race, ethnicity, gender, religion, national origin, or sexual orientation. This became the basis for civil rights challenges in the 1950s and 1960s in cases like Brown versus the Board of Education, Bailey versus Patterson, and Loving versus Virginia. The 4th Amendment prohibits unreasonable search and seizure of a person, property, or contents without probable cause. The major source of procedure challenges to law enforcement activities come from search and seizure laws or search and seizure violations. Cases like Weeks versus the United States in 1914, Mapp versus Ohio in 1961, and Terry versus Ohio formed the legal precedents revolving around unreasonable search and seizure. In terms of bills of attainder and ex post facto laws, a person cannot be punished for a crime retroactively through a bill of attainder, which is a legislative act declaring persons or groups guilty of a crime and subject to punishment without a trial. For example, a member of a political party can't be prohibited by law from serving on a union board retroactively. This maintains the separation of powers between the legislative branch, the judicial branch, and the executive branch, meaning that the legislative branch cannot become engaged in judicial or executive acts. This maintains a due process of law, which means persons have the right to trial and other due process protections. Ex post facto laws makes an action criminal conduct that was not criminal when performed or retroactively, or increases the punishment of crimes already committed, changes the rules of procedure enforced at the time of an alleged crime and when it was committed in a way that is substantially disadvantageous to the accused. Some legal precedent for prohibiting ex post facto laws is found in Beazell versus Ohio in 1925. Fair notice means the law must clearly define the precise conduct that's prohibited. Statutes can't be ambiguous or vague. A person must know what to do in order for them to shape their own behavior. This is a requirement under the 5th and 14th Amendments due process clauses. Legal precedents revolved around fair notice and vagueness were established in Colliander versus Lawson in 1983 and the People versus Manis in 2000. The second part of type of criminal law in the United States is what's known as the substantive criminal law. This is a substantive criminal law is when definitions of criminal law are established and provides punishment for committing the law, a violation of the law is established by legislative action. The ability to define what's criminal conduct is limited by the Bill of Rights. These are what's known as the substantive rights of individuals in our country. Things like the freedom of religion, speech, and assembly under the First Amendment, the right to bring grievances against the court, which is what's called the First Amendment Petition Clause, the right to keep and bear arms under the Second Amendment, and the protection against cruel and unusual punishment under the Eighth Amendment are examples. Within the First Amendment, the freedom of speech has declared that legislative precedent has declared that the guarantee for free speech is not absolute. Certain speech can be regulated in accordance with the clear and present danger test that was used by the Supreme Court in Shinnick versus the United States in 1919, which basically equates to you can't falsely yell fire in a crowded movie theater. Certain speech can be regulated as well in terms of things like fighting words, hate speech, profanity, libel, and obscenity speech. Within substantive criminal law, under religion, the First Amendment right to freedom of religion, the courts have generally invalidated statutes that are veiled attempts to restrict religion. For example, banning door-to-door solicitation and animal sacrifice. However, some statutes have been upheld, like the use of drugs and even polygamy. Under right to assembly, there's reasonable restrictions that can be imposed when the public safety and order are threatened, or in cases when access to medical facilities are being limited. Anti-loitering laws have been used to restrict assembly in many states, but these may be subject to vagueness tests upon appeal. Under the Second Amendment, the right to keep and bear arms isn't absolute. You have federal and state gun control laws laws that require background checks, waiting periods to purchase handguns, restrictions on carrying weapons openly, requirements to carry concealed. To get a concealed weapons permit, you're required to undergo training and go through a permitting process. There are laws that restrict purchasing firearms. Of course, convicted felons are unable to purchase, possess, or utilize firearms. And under the Brady Bill, more severe penalties were added to crimes when those crimes are committed with the firearm. Under the Eighth Amendment, this is the prohibition against cruel and unusual punishment. There's often proportionality requirements that affects this cruel and unusual punishment argument. You have offense grades, things like the death penalty, and terms of imprisonment that are considered in cruel and unusual punishment appeals. Under non-capital cases, the court hasn't been clear on what they consider proportional, but under capital cases, there's been considerable thought and judicial opinion and judicial decisions on placing limitations on the death penalty under the Eighth Amendment. In 1972, the case of Furman versus Georgia placed a hold on the use of the death penalty. The majority ruled in this case that the death penalty discriminated against minorities and the indigent, those that could not afford their own defense. But in 1976, you have what's known as the July 2nd cases in Georgia, Florida, Texas, North Carolina, and Louisiana, where Eighth Amendment challenges against revised capital punishment statutes were a response to the Furman decision. The court ruled that when the jury is furnished with standards to direct and limit the sentencing discretion by the jury or by the judge in a capital case, the character and record of the accused has to be considered. The jury's decision is subjected to meaningful appellate review. In these cases, when these elements have been proven, the death sentence may be constitutional.